If you had a family member to pass and a will was never created, who inherits the property? Today, that's what we're going to talk about. Hi, I'm Denise Davis, a North Carolina realtor and a certified probate real estate specialist, and I help people who are going through the probate process or who needs to file probate and who also has real estate to sell. Now, this is a new YouTube channel, and I ask that you please help me to reach my goal of getting 100 subscribers by subscribing to the channel, hitting the notification bell, and if you like the video, give it a thumbs up. Now, let's dive in. In North Carolina, if a person died without a will, it is not the spouse, it is not the oldest child, it is not the executor nor the administrator who dictate who is going to get what part of the inheritance. I received a phone call from an administrator and we was talking on this topic, and she basically told me that there was a certain heir in the family that they were not planning on contacting because they were not planning on giving him anything. So I had to inform her that in North Carolina, it did not work that way. If she did so, she could possibly find herself in court or possibly paying fines and even possibly facing jail time. In North Carolina, when a person dies without a will, a law called the North Carolina Intestate Succession Law steps in. So what is this law? The North Carolina Intestate Succession Law determines how a deceased person's property and assets will be distributed among the heirs. Basically meaning who's first in line to receive. Is it the spouse? Is it the children? Is it the parents? Is it the aunts and uncles? And so on and so on. Now, before we dive in, I think it's important for you to know and understand that there are certain assets that are excluded from this law. Meaning if the assets fall into a certain category, you could say, it bypasses the intestacy law and it also bypasses probate. And it goes straight to the person that the deceased person named to receive it. For example, if someone opened up a bank account or opened up a life insurance policy or even a retirement account, and they named a beneficiary to receive the funds upon their death, these type of accounts are excluded from that law and the funds will go straight to the beneficiary. Now, if before dying, the deceased person had named a beneficiary in his will instead of on an account, the will would have to go through probate, and there would be a chance that the beneficiaries would not receive the assets left to them if creditors come forth and file a claim against the estate. Because if this happens, there's a chance that those assets may need to be sold in order to pay the creditors off. Now, also excluded from the North Carolina intestacy law are any assets that are titled as joint tenancy with right of survivorship. Now, this is a legal term which means two or more people who own assets jointly. If one of the owner dies, the other owner gets full ownership of the asset. This is why it does not have to go through the North Carolina intestacy law. The type that is also excluded from the North Carolina intestacy law are assets titled as tenancy by entirety, which applies only to married couples in North Carolina who has purchased the asset together. When one dies, the surviving spouse automatically takes over the decedent's part of the property. Now, there are some stipulations to this, but I'll get into that in another video. Now, if these four things does not apply, a beneficiary named on account, assets titled as joint tenancy with right of survivorship, or tenancy by entirety, or if there is not a will, then this is when the North Carolina Intestate Succession Law steps in. And this is how it happens. The probate court will designate an estate administrator to locate the assets, to settle all debts and taxes, to settle burial expenses, and then distribute any remaining funds or assets to the beneficiaries and or heirs. So although an administrator has been appointed, it is not the administrator who determines which heir is going to get which asset, or which heir is going to get which property, and which heir is going to get a certain amount of funds. Because one, that is not their responsibility to do so. And two, because they have to file a notice to creditors. And if the creditors make a claim against the property, the assets that they may have been planning on giving to the heirs may have to be sold to pay the creditors off. Now, once they get past paying the creditors off, they're done with that. And now it's time to focus on the beneficiaries and the heirs. However, there are three things that first needs to be known. One, was the decedent married? Two, did the decedent have children? And three, does the decedent have living parents? Now let's look at the breakdown of this. If the decedent was single and had no children, but had living parents, then all of the estate, all of the property would be divided amongst the two parents. If only one parent is living, then all of the property would be given to that one parent. If the decedent had a living spouse, but no children, but he did have living parents, the spouse would get half ownership of the real estate and his parents would get the other half. So they are both owners of the real estate. And as far as the personal property, the spouse would get the first $100,000, and anything in excess of that, they would get half of that, and then the rest would go to the parents. Now, for example, if they sold all of the personal property, automobiles, boats, stocks, bonds, furniture, things like that, and let's say the total came up to $150,000. The first $100,000 the spouse would get. The $50,000 that's remaining, they also get half of that. So they would get another $25,000, and then the other $25,000 would go to the parents. If they decided to sell the real estate, let's say a house, they would get half of the money and the parents would get the other half. Now, I'm gonna be honest, I had mixed feelings on that part. I don't know how I would feel about that. But anyway, let me know how you feel about it. So let's say if the decedent had a spouse and had one child and had parents. Now, in this case, the parents have nothing to do with it because there is a child. So the parents is pushed back. But as far as the spouse and the child, when it comes to the real estate, the spouse would own 50% and the child would own 50%. And when it comes to the personal property, the spouse would get the first $60,000, and then anything in excess of the $60,000, they would get half of that, and then the remaining half the child would get. Now, if the decedent had a spouse and two or more children, then as far as the real estate, the spouse would get 1/3 of the real estate, and the remaining value would be distributed evenly amongst the children. Now, as far as the personal property, the spouse would get the first $60,000, and then 1/3 of anything in excess of $60,000, and then the rest would be distributed among the children evenly also. Now, if the decedent is survived by children only, then each child would receive an equal share of the property. And if it was only one child, then that child would receive the entire estate. So now, if there was no spouse, if there were no children, and there were no living parents, then the state would allow other family members, such as siblings or uncles and aunts and so on, to be named as an heir. And if there are no living heirs, then the state of North Carolina would become the beneficiary of the estate. And this is also called a sheet. So I hope this helped you understand who would inherit the property if there was no will in North Carolina. So if you have any further questions, leave them in the comment section. But let me know, what do you think about the spouse having to own the property with their in-laws? Do you think this is fair or not? I'm curious to know. And remember, if you're looking for a North Carolina realtor to help you sell your inherited property or property that's included in probate or just a traditional sale, contact me. You can call me, email, or text me. You'll find all my information below. Thank you for watching this video. I'll talk to you again in the next one. Be blessed, and don't forget to subscribe.